So we are watching landmark judgments and their effects, and I'm making this particular course for supplementing your UPSC preparation, because many times in polity you will see reference of many cases, and that's why it is a supplement course. And there are few other cases like Ramesh Thapar and Shrimati Champakam case. In this particular lesson, we are going to discuss about Shankari Prasad case, then Golaknath case, Keshav Nanda Bharti case, and they are in a sequence, right? And we are also discussing their effects. Also, you must not know what the verdict is, but you also have to know what their effect on our judiciary or legislature or on our society as a whole, right? So do watch all these cases to understand polity better. So this is our second case, Shankari Prasad versus Union of India case 1951. And what is the background of this particular case? And that's why it is also important to watch the first case, because there are interlinks between all these cases. And what is the background of this particular case? Look, when we have adopted our constitution, the state governments are trying to trying to abolish the zamindari system, and trying to bring the land reforms and the various codes. And since the land reforms are violating the fundamental rights of people are going to court, and various courts like the court of Patna declare those laws which are in the state of Bihar, say the court of Patna declares them unconstitutional, whereas the court of Allahabad and court of Nagpur says no, these particular laws, the land reforms are consistent with the constitution, sorry. And therefore there was a confusion in the country that few state courts are declaring, few high courts are declaring the laws as unconstitutional, and the other ones are declaring it constitutional. So there was a confusion in the country, and in between all this chaos, the first amendment happened, and the ninth schedule was invented by our legislature. And therefore this particular case, Shankari Prasad versus Union of India case, was not against the land reforms, because now it is put under the ninth schedule. And since the constitution says you cannot review, or you cannot put any law which are under ninth schedule into scrutiny, this particular case cannot scrutiny the ninth schedule or the zamindari laws. So what this case is about? This case is on the validity of first amendment. Now first amendment can be challenged, which brought in the ninth schedule, it can be challenged. So this particular case, Shankari Prasad versus Union of India case, was not on land reforms, because till this case happened, the ninth schedule was invented, and the land reform laws or acts are put under ninth schedule. So it the constitution says so, you cannot review it. Clear? I hope I made my point clear. Now the article 13 was in question in this particular case, and I had written down here the gist of article 13. If you want, you can go to Google and you can read the full article 13, but you can understand it by this particular gist. And it says all laws in force, if found inconsistent with what? Our constitution. If found inconsistent with our constitution, can be declared null and void. That is the gist of article 13, right? All laws, right, if they are inconsistent, they can be declared invalid. Clear? Now what Supreme Court says? Supreme Court says that ordinary laws and amendments are two different things. Supreme Court goes to the literal meaning of laws here, and this is the constitution maker has mentioned only laws here and not about the amendment. And since amendments are two different things, that's the judgment or the verdict of this particular case, that laws and amendments are two different things, and only laws are mentioned in article 13. Only laws can be declared invalid, or laws can be declared null and void. We cannot scrutiny, or we cannot declare any amendment null and void. And therefore the first amendment survived, because it was not a law, but it was an amendment into the constitution. And What is the original Article 13? The conflict is between these two. The original Article 13. Now the Article 13 is amended again, but the conflict in Shankari Prasad versus Union of India case was between original Article 13 and Article 368, and I had mentioned Article 368 in the previous case, and that's the reason of mentioning it there. And Article 368 is on amending power of our legislature. And what is the effect? What is the effect of this particular case? Total amending power was given by Indian judiciary to parliament, right? That's the effect. And that's a great thing to happen, because that now the court says in Shankar Prasad case that okay, if you frame a law, we are going to review it and we are going to declare null and void if we find it unconstitutional, but we are totally cool with the amendment. If you brought in an amendment, it's not written in our constitution, it not there was no mention of amendment in Article 13, and we cannot declare it null and void because there is no reference of amendment in it, right? So this is a very great effect, because the next case, which is Golaknath case, is going to repeal this particular judgment. And but look, this particular case happened in 1951 and Golaknath case happened in 1967, so it's a big time. So this particular case has a big effect, and in this particular case we are going to see, or we had seen, not going to see, we had seen that in the previous case, the parliament invented a 9th schedule, and in this particular case, which also happened in 1951, the the judiciary confirms that total amending power was given to Indian Parliament or Indian legislature, right? So this is the effect. That's all for this particular case, and now we are going to see the Golaknath case. So I'm also giving my Facebook ID link in the info section. If you want, you can add me there. If you want the PDF file of this particular lesson, you can also contact me there, and I will provide you the PDF file of this particular lesson. And you can also view my lessons on Unacademy if you want to. Thanks.